And you have to see the framework of the Act in the backdrop of the economic policy which prevailed before 1991. The Act was thereafter substantially amended in 1984 to bring in provisions on unfair trade practices, and again in 1991 when the policy of deregulation was set in motion, the Act required to be changed. The focus of the MRTP Act was on size and control of market power. The dynamics of the reforms of the 90s called for more than just amendments. An expert committee was therefore set up by the government in 1999. It recommended replacing the MRTP Act with a modern competition law for fostering competition and targeting anti-competitive practices. Accordingly, the Competition Act was passed in 2002, whereunder the Commission has been set up. When the Act was being proposed, there was a debate on whether the country and business really needed a competition law so soon after 10 or 11 years after deregulation. The debate got settled in a somewhat perverse manner. The Act of 2002 had a legal challenge and was therefore not enforced. It had to be amended in 2007, and it was substantially enforced only from May 2009. That's 3 years ago. In fact, the provisions concerning mergers and acquisitions were enforced only 1 year ago. In that sense, competition enforcement and the work of the Competition Commission as a market regulator is of recent origin. As in most competition laws around the world, the Indian Act has three main pillars. One, prohibiting anti-competitive agreements, and this includes cartels, which are the extreme form of such agreements, which is covered under Section 3 of the Act. Two, prevent abuse of dominant position, which is Section 4. In some countries, as you would be aware, it's called unilateral action. Here it's called abuse of dominance. And let me say that the Act does not specify any particular threshold in terms of percentage or size and so on, whereafter a firm or a group would be considered dominant. It's a qualitative judgment based not on numerical numbers, but based on the activities, the behavior, and the actual abuse of dominance. So the Act's stress is not so much on dominance per se, but on abuse. And that's Section 4. The third plank is the regulation and approval of mergers and acquisitions above a certain specified threshold, which are Sections 5 and 6. And this also, in a way, links up to the other two provisions, because mergers and acquisitions require the prior approval of the Competition Commission, apart from approvals that may be required under the company law and from the High Court's concern. But the idea is that from the market or competition point of view, the merging entities should not become so big as to cause distress in the marketplace. What is the applicability of the Indian competition law? Unlike MRTP, which had exclusions, the competition law applies to all enterprises engaged in commercial activities, except, and it applies also, therefore, even to government departments which carry on commercial activities, for instance, railways, Indian Railways. And it may not be a public sector entity or a corporate entity, but it's an enterprise, and that's the word used in the Act. So it covers every activity, every entity engaged in commercial activities except government departments in the discharge of their sovereign functions and activities in space, atomic energy, defense and currency. The Act also has a somewhat unique feature which most other legislation don't have, is the provision for advocacy, which is built into the Act. And the legislature put this in specifically because it's to deal with an emerging India which is in a position of transition from an India where there were old rules, where the state was important, where the rules were framed in a different manner, and therefore advocacy, so that the Commission, while discharging on the one hand its judicial functions, is also supposed to communicate, disseminate about the Act, and this was referred to by the Chief Secretary in his address. And we've been doing that with various stakeholders, not just the Chambers of Commerce and Industry, but also colleges, universities, educational institutions, and certainly, of course, with the legal fraternity and law schools and so on, where we have very live connection. But advocacy is under Section 49, one of the provisions built into the Act. The Act also provides that the central government and the state government may, on matters of policy where they need advice on competition-related issues, make a reference to the Commission, which is bound to give its recommendations or advice within a period of 60 days. Of course, it's another matter that the discretion whether to use that advice or not is with the central or state governments, which is in a way typical of our legislations. During the last 3 years, the Commission has received 267 matters alleging violations of Section 3 and 4 relating to agreements and abuse of dominance in diverse sectors such as insurance, automobile manufacture, real estate, pharmaceutical, financial sector, and the entertainment business. And these matters can come up both by way of information from anybody, need not be a person who is in any way aggrieved. So it's not a complainant, it's not a person who has actually suffered. The word used in the Act is informant. So the informant, if he has some information, he can pass it on to us, and we will see whether it needs to be carried forward and is fit to be proceeded against under the competition law. And of course, the Act also gives us the power to take up matters soon. Of these 267 matters, the Commission has passed final orders in more than 200 cases. Penalties have been imposed where warranted. Where after inquiry it has been found that competition could be better served if certain government policies are modified, the CCI has suggested changes in such policies. The law is thus slowly but surely beginning to bite. As regards M&A, we appreciate that Indian industry needs to consolidate and grow in an inorganic manner. It is this spirit that informs our handling of cases in which there are prima facie no competition concerns. Since the notification of sections 5 and 6 in June 2011, the Commission has decided 56 cases, all within 30 days. As the merger thresholds have been consciously kept at a high level to start with, and the economy is sluggish, the number of filings are perhaps relatively less, but they will increase and become more complex. In all such matters, as industry knows very well, time is of the essence. While the Act provides for 210 days in all for a decision thereon, and particularly where the matter goes into a detailed investigation, the Commission has a self-imposed limit to clear cases within 180 days. And in matters where prima facie there is no need for detailed investigation, as I said, we decide within 30 days so that we don't hold up the normal process of consolidation. In spite of the constructive approach that the Commission has tried to follow, some sectors and government agencies concerned have started seeking exemption from the provisions of the Competition Act. This is being put forward on the specious plea that the sectoral regulators are equipped to handle matters concerning those industries. The sectoral regulators are no doubt competent and have domain knowledge, but they are equipped to handle only technical and tariff or royalty related issues. Issues of ex post behavior as distinct from ex ante analysis. Issues of competition and interrelated matters of M&A has to be the function of the market regulator. That is not only appropriate and desirable, it is also the best international practice. Finally, let me touch on the extremely vital aspect of consumer welfare for the common man. While protection of the interests of consumers is in the preamble of the Competition Act, the Consumer Protection Act, COPRA 1986, is the act dealing directly with the consumer. Competition Act focuses relatively more on B2B and incidentally on B2C. International framework in this regard suggests different models. In a few countries in Africa, there is a hybrid law dealing with both competition and consumer protection. In a few cases, most notable of them being Australia, there are different laws but a hybrid agency. This is the famous Australian Competition and Consumer Commission. Most countries, though, have separate laws and separate agencies. This is the practice we follow in India also. Essentially, the COPRA Act concerns itself with unfair trade practices. On the other hand, the Competition Act has a wider mandate to look at actions that stifle competition. The former focuses on the demand side, the Competition Act on the supply side. Yet both legislation have a common goal and a common spirit: to deal with distortions between supply and demand in the marketplace. The end result is benefit for both ends of the chain, the producer and the consumer. Ladies and gentlemen, let me conclude by recalling what the Prime Minister, Dr. Manmohan Singh, had said in his speech at the annual general meeting of a National Industry Chamber in 2007. He had mentioned that there are 10 areas in which industry leadership can help to ensure that our growth process is both inclusive and broad-based. One of the areas, he stated, and this was as early as 2007, was the need for robust competition. And I quote, "Companies should desist from non-competitive behavior. The operation of cartels by groups of companies to keep prices high must end. It is unacceptable to obstruct the forces of competition from having fair play. It is even more distressing in a country where the poor are severely affected by rising commodity prices. Cartels are a crime and go against the grain of an open economy. Even profit maximization should be within the bounds of decency and greed. If a liberalized economy has to succeed, we must give full play to competitive forces, and the private sector should show some self-restraint in this regard." This was his exhortation to not just industry but to all stakeholders, and the year, let me remind you, was 2007, even before the amended Competition Act was enacted and became operational much later. With these words, thank you very much, ladies and gentlemen. I am indeed privileged to have been given the opportunity of delivering this inaugural address in the series started by SPIPA.
This program is also being live webcasted on the websites of SPIPA and FICCI. I now request Shri Agarwal, Director General SPIPA, to kindly moderate the question and answer session.
We have received a few questions while the address was in motion, and others are being collected. I would request the officers of FICCI and SPIPA to kindly give them to Mr. Param Shah behind me. I will take up the questions one by one to see that time is well spent and properly utilized. We have examined the questions, and the ones we feel that really are of very high quality and should be taken. We have prioritized them early. So, sir, I will just read out the questions. The first question is from Ms. Shilpi Thapar from the Institute of Company Secretaries of India. I would request Ms. Thapar to kindly just raise her hand and so that audience may see her. Sir, the question is, will CCI be able to use its powers to control international mergers or export cartels which are being promoted and protected by their own government? If such international mergers or export cartels have an adverse effect on competition in the Indian market.
Yes, the Act specifically provides that where there is a merger which is taking place outside the country, or there is an economic activity which has an impact on competition and on markets in India, the CCI can take action. So it's specifically provided in the law.
The next question is by Dr. Gauri Trivedi. Please, sir, she is there. Can we call CCI a game changer? Arvind Panagri called CCI a game changer, citing the matter of prepayment fine imposed by banks, which is currently under investigation by CCI. Mr. Panagria argues that CCI is probably the most important reform recently. Any comments, sir?
I don't think we should get carried away with these sort of expressions, but the law as it's given to us is fairly robust and strong, and if it is implemented well, I think it's good.
The next question, sir, is by Mr. C.K. Koshi. Can an issue settled by a regulator, example electricity tariff by CERC, be posed before the CCI? This is the first question.
Can you repeat the question?